And here with us now is Christopher Ferrara, a Thomas More Society lawyer working to allow churches to reopen. Christopher, thanks for being with us on Faith Nation today. The judge here in this case is Gary Sharp. I take it he was pretty critical of Governor Cuomo and Mayor de Blasio.
Well, I think the court had to be because the position was essentially indefensible. There's a vast network of regulations governing capacity limitations of various businesses and entities. And I look at it as a kind of inverted pyramid. At the very bottom of the inverted pyramid, all alone in the 25% indoor occupancy limitation, was religion, just religion, nothing else. Now, on the eve of the judge's ruling, I understand that the governor has leapfrogged religion into phase 4 throughout the state. But even in phase 4, religion, and religion only, is at 33% indoor occupancy, whereas the judge's ruling issued today says essentially this, that religious gatherings, like other business gatherings, are entitled to a 50% occupancy limitation. There's no rational basis to distinguish, for example, restaurants at 50% capacity from a house of worship at 50% capacity. So he held that the regulation of capacity limitations was not generally applicable. He reserved the question as to whether it was neutral on its face, but found that it definitely was not being applied in a generally applicable way, and that religion had been singled out for an especially strict gathering limitation indoors. And as to the outdoor gatherings, he said that these are essentially gone now, with the massive exception allowed for protests of unlimited numbers. So he held that outdoor gatherings cannot be limited. As to our clients, they need only practice the social distancing guidelines for outdoor gatherings, but there's no longer a strict numerical limitation to 25 people in the North Country, for example, or 10 people, which was applicable in the lower half of the state, especially in New York City. That's gone now because they have effectively abolished that whole framework by allowing these massive demonstrations. And they should allow demonstrations. They're First Amendment protected activity. It's not even just the demonstrations, it's also celebrations of Juneteenth, for example. Thousands were demonstrating and celebrating for the Juneteenth celebration on the 19th of June. Essentially, New York is now just filled with gatherings and celebrations of all kinds. So that outdoor gathering limitation is essentially history at this point.
Just a few seconds left here, but what's the immediate effect of this judge's ruling today?
Well, the immediate effect as to these plaintiffs is that they're relieved of these indoor restrictions at 25%. The restriction should be 50%, as with comparable businesses, and they're relieved of any outdoor gathering limitations. There is no outdoor gathering limitation any longer. They need only practice social distancing.
We're out of time. We're going to have to go. I'm so sorry.
That's
Thanks
okay.
for being with us today.
Thanks, Christopher.